Good afternoon. Thank you for taking time to attend our Employment Law Update webinar this afternoon. For those of you that don't know us, I'm Jane Bowen and this is my colleague Emily Russell. We're both solicitors in the Employment and Pensions team and are going to be talking to you this afternoon about 3 separate topics. Before we start, just a couple of housekeeping points. The slides will be sent to you afterwards by email, so don't worry about furiously scribbling down whilst we're on the session this afternoon. There will be the opportunity for question and answers. Because we're talking about 3 quite discrete topics, we're happy to take questions at the end of each section. So please do, as anything arises, type it into the Q&A button at the bottom of the screen, and we will be answering the questions at the end of each section. They will be anonymous, so please feel free to ask whatever you like. We're not going to name people, but equally this forum works better when it's more general questions that are asked. So I guess as a general rule, anything that's taking you kind of over 2 to 3 lines to write is probably a little bit more specific than we would intend for this forum, but please do pick it up with myself or Emily afterwards. We'd be happy to help. Last housekeeping point, there will be a short feedback survey link that will appear for you post-webinar. We'd love to know your thoughts about how you found today and if there's any possible topics that would help you for us to cover in the future, in future webinars. So it would be great if you could participate in that survey when we come to the end of the session. So just looking today at what we're going to talk about, you will all have been aware, I'm sure, that in April 2020, so just a couple of months ago, the concept of statutory parental bereavement leave and pay was introduced. So the first topic on the agenda will be to cover that. We will then move on to a brief reminder on whistleblowing before considering case law earlier this year and whistleblowing in light of COVID-19. And the third topic is return to work after lockdown. I'm sure many of your businesses will already be slowly returning to some sense of normality or the new normality. But as part of this session, we'll look at employers' obligations and provide some kind of practical scenario-based advice on what happens at the end of furlough and what happens if particular categories of people won't want to return to the office. I'm now going to hand over to Emily, who is going to cover the first 2 topics on our agenda today.
Thank you, Jane. So I'm going to be covering firstly parental bereavement leave and pay. So as I'm sure you're all aware, from the 6th of April 2020, all employees who suffer the loss of a child under the age of 18 or suffer a stillbirth after 24 weeks of pregnancy will be entitled to 2 weeks statutory leave. This leave is to be taken as 1 week, 2 consecutive weeks, or 2 separate weeks within the first 56 weeks after the loss. Employees who are eligible for the leave may also be entitled to statutory pay of £151.20 a week, or 90% of their average weekly earnings, whichever is the lower. An employee must meet the eligibility criteria as a parent and an employee in order to be entitled to both bereavement leave and bereavement pay, but I will explore this in more detail on the later slides. So, parental bereavement leave. To be eligible for parental bereavement leave, the employee must have suffered a loss of a child under the age of 18 or suffer a stillbirth after 24 weeks of pregnancy. They must be classed as an employee, regardless of their length of service, and they must meet the criteria of being a parent or guardian of the child. In order to meet the definition of being a parent or guardian of a baby or child, an employee must fall within one of the following categories. So they must either be a biological parent, adoptive parent, a prospective adopter, an intended parent under a surrogacy arrangement, a parent in fact, which means someone looking after the child that in that person's own home for the last 4 weeks, or the spouse, partner, or civil partner of any of the above options. Paid carers do not fall within the definition of a parent or a guardian. The employee also needs to comply with the strict notice requirements on when they want to take leave and how much leave they are taking, but I will come on to this in more detail a bit later on. So parental bereavement pay. To be eligible for statutory parental bereavement pay, an employee must have been continuously employed by their employer for at least 26 weeks up to the end of the relevant week. The relevant week is the week ending with a Saturday immediately before the week of the death or the stillbirth. The employee must remain employed up to the day the child dies or is stillborn and must earn on average £120 a week gross. Again, the employee will need to give the correct notice to be able to claim statutory parental bereavement pay. Some clients are enhancing the statutory pay to full pay in accordance with their other family-friendly policies, and some clients are also waiving the requirement for the employee to have 26 weeks service and saying that employees can take their bereavement leave anyway. If employers do decide to do this, they wouldn't be able to claim the pay back from the government, and some employers are deciding to do this anyway. We would advise that it's good practice to introduce a parental bereavement leave policy that employees can refer to if they need to know about parental bereavement leave. It would be more sensitive to have this policy as a standalone policy rather than being included in your general staff handbook. So moving on now to the notice requirements. So in respect of parental bereavement leave, notice should be given either before the time the employee would normally start work on the first day of the period, if this is within 0 to 8 weeks of the death or stillbirth of the child, or if 9 to 56 weeks have passed from the date of the death or stillbirth of the child, they need to give 1 week's notice before the period they wish to take the leave. The requirement for employees to give a week's notice after 9 weeks seems strange, as it's unlikely that employees will know when they're likely to need a week off work because they feel bereaved. But it's up to you as an employer to be flexible around these notice provisions. Being flexible will have no impact in terms of the leave. However, it does complicate matters in respect of the pay, and employers may not be able to claim this back from the government if they are flexible in terms of the notice requirements. In relation to parental bereavement pay, notice should be given before the start of a period of leave or within 28 days starting with the first day of the week the employee wants to claim for. So now we're going to have a look at what form the notice needs to take. So again, looking at parental bereavement leave, whilst the notice provisions in relation to bereavement leave do seem particularly onerous, given the circumstances in which this leave will be used, the guidance does make it clear that the notification can be given by informal means, so such as by phone, text or email. Employers cannot ask for the notice to be in writing, and they can't ask for any evidence of entitlement to leave or details about the employee's relationship to the child or baby. In their notification, the employee must give the employer notice of the date of the child's death, the date on which the employee chooses the leave to start, and whether the employee intends that period to be 1 or 2 weeks long. In relation to parental bereavement pay, to ask for parental bereavement pay, the employee must, within 28 days, starting with the first day of the week they want to claim for, give notice in writing of, firstly, the date of the period they're claiming, the child's name and the date of the child's death or stillbirth. They must also give a self-declaration to confirm they are eligible because of their relationship to the child or baby. Although this appears complicated, it actually need not be. In many cases, upon the death of the child, the employee would simply have a conversation with their employer and would state that they would like to take leave, and this would be treated by the employer as sufficient notification for bereavement leave. The employer would then ask the employee to fill in a form or send an email confirming statutory parental bereavement pay purposes, the dates of leave and pay, the dates of the child's death and their relationship to that child. It may be that you want to create a template for these purposes to make things slightly easier. The 28-day window gives the parties the necessary flexibility to deal with the administrative side on return to work, rather than at the time of the child's death, when the employee will understandably have more pressing things on their mind. Finally, I'm having a look at cancelling leave or pay. So the employee can cancel or change the date of leave within the same period of notice as explained a little bit earlier on. So in other words, for leave that is due to start within the first 8 weeks of the death or stillbirth of a baby or child, leave can be cancelled by giving notice before the time they are due to start work on the day that the leave was supposed to start. If this is not possible, the employee must notify their employer as soon as reasonably practicable. For leave that is supposed to start after between 9 and 56 weeks after the death or stillbirth of the child, the employee can cancel it by giving notice of at least a week before the leave was due to start. A period of leave cannot be cancelled once it has started. I've just had one question come in on this. So the question is, so if an employee wants to take bereavement leave tomorrow, they cannot give notice in respect of bereavement leave for 28 days. No, they can give notice now. The requirement is that notice for statutory bereavement pay must be given within 28 days. So they can give it now.
I've actually just noticed one more question, Emily, as you've been talking. It's come in, and it's someone that's mentioned that they don't understand the notice to be given upon the death of a child, because normally parents would be automatically be off when a child dies. Therefore, can it be retrospective? As mentioned by Emily, if it comes within the first 8 weeks, then the notification simply has to be before the time they normally start work. So the notification to the employer can be informal, by phone or text. So if you wanted to do so, you could take the communication from the employee to the employer as notice that they want to be off, and use that as bereavement leave. And so it will normally before they start work anyway. But notwithstanding that, Emily mentioned that employers can choose to relax the requirements for the notification, and really it wouldn't have any impact on the period of leave itself. But what it might have an impact on would be to the ability to claim the statutory payback from the government if that person's taking pay as well, because strictly the notification requirements as set out in the legislation wouldn't have been complied with. That isn't to say you couldn't accept that, but it's just to say that it would potentially be a cost that you bear yourself, as you wouldn't be able to claim that back. Okay, I think we can move on now. Those are all the questions we've had. So I think Emily's now going to move on to whistleblowing.
Thanks, Jane. So we wanted to cover this topic as we have seen a general rise in cases, which could be further heightened as a result of COVID-19, where organisations may start to see a rise in complaints about health and safety at work. Employers will need to be mindful that employees may assert that their complaints about inadequate measures being put in place amount to a protected disclosure for whistleblowing purposes. So what is whistleblower protection? By way of summary, there is legislation which protects whistleblowers from detriment and dismissal because they have made a protected disclosure. So a qualifying disclosure means any disclosure of information which, in the reasonable belief of the worker making the disclosure, is made in the public interest and tends to show one or more of any of these things listed on this slide have occurred or are likely to occur. I'll just give you a second to have a look at the list there. So when is a disclosure protected? In order for a qualifying disclosure to be protected, it must be made to one of the following categories of people. So it needs to be made internally, so to the worker's employer, or to certain other third parties. So for example, it could be made to the person or the body responsible for regulation. If the disclosure is made more widely, there are more stringent conditions required in order to qualify for protection. For example, if an employee chose to make a disclosure to the press, the employee would need to be able to prove that they had already disclosed substantially the same information to their employer first, and that they had not made the disclosure to receive any form of gain. Disclosures can be made either during or after employment, and a disclosure can only be a qualifying disclosure if the worker reasonably believes that the disclosure is in the public interest. Therefore, if a disclosure made by an employee only relates to them, this should be dealt with under a grievance policy. Something we see quite often are quasi-whistleblowing disclosures and grievances raised, and we generally advise that these should be dealt with separately under their requisite policies. So now we're looking at what a detriment is. So as you know, workers have the right not to be subjected to any detriment on the grounds that they have made a protected disclosure. Case law has found that a worker suffers a detriment if a reasonable worker would or might take the view that they have been disadvantaged in the circumstances in which they had to work. The Whistleblowing Commission Code of Practice sets out examples of disadvantages that could amount to a detriment. These are detailed on the slide here. So examples include failure to promote someone, denial of training, close monitoring, suspension, demotion, disciplinary action, pay cuts are just some of the examples. Where an employee does suffer a disadvantage, it's up to the employer to show that they had a good reason for doing so. Clients are often concerned about doing anything to a whistleblower on the basis that it could be seen as being a detriment. But it is important to remember that there needs to be a causative link between the protected disclosure and the treatment. I know, Jane, you've had a recent case example which illustrates the point that there needs to be a causative link.
Yeah, thanks, Emily. Even pre-COVID-19, we had actually seen an increasing number of whistleblowing issues that our clients were having. And there's one particular situation which I think illustrates this point quite well. The situation was there was an employee that had made a health and safety disclosure in respect of the workplace. They were a maintenance employee and they were signed off sick for various reasons. They remained off sick whilst the employer was investigating, and prior to reaching a conclusion in that investigation, the employee was notified that their sick pay was going to be reduced to half pay in accordance with their sick pay entitlement. And the employee, in response to that notification, said to the employer that he believed that reduction in sick pay was a detriment as a result of his protected disclosure. So looking at the test that Emily mentioned on the slide about there being a causative link between the protected disclosure and the reason for treatment, my advice in that scenario was there was no detriment. The reason the sick pay was being reduced was because that person's entitlement to full pay had been used up, and actually had nothing to do with the fact that he'd made a protected disclosure. And further evidencing this was the fact that he was signed off sick for unrelated reasons to the whistleblowing. I think it was due to their own health and the health of someone in their family, which was causing a particular stress to that person. So I think it's an important point to remember that clients are quite often concerned that whistleblowers are not, are protected and not subject to a detriment, but that is not to say that they've got carte blanche to do whatever they want in the workplace, such that they're rendered untouchable. So you can continue to go through your internal processes should you need to do so, to the extent you're comfortable there's no causative link between the process that they're being taken through and any protected disclosure that they've made.
Thanks, Jane. So there is a recent Supreme Court case that I wanted to cover here. So I'll go through the facts of the case first, and then we'll talk about lessons learned and what we need to think about going forwards. So the case is Royal Mail Group and Duty. So Mrs. Duty was a media specialist employed by Royal Mail. She made a protected disclosure to her line manager out of concern that the way some incentives were being offered to clients was in breach of regulatory guidelines. In response, her line manager actually pressured her into withdrawing these allegations. Mrs. Duty was then subject to bullying and harassment by her line manager under the guise of performance management, including being set unattainable targets and being required to attend weekly performance meetings. Another manager was asked to assess whether Mrs. Duty should be dismissed and was provided with performance management information by the line manager. This manager was completely unaware of the whistleblowing allegations or the full details of Mrs. Duty's complaints. Mrs. Duty's line manager had actually manipulated the information given to the dismissing officer, and Mrs. Duty was dismissed on the basis of unsatisfactory performance, following which she brought a claim in the Employment Tribunal for unlawful detriment and automatic unfair dismissal arising from a protected disclosure. Mrs. Duty succeeded on the detriment point, but was originally unsuccessful in her claim for automatic unfair dismissal on the basis that the decision maker was unaware of the protected disclosure and made her decision to dismiss her in good faith. However, Mrs. Duty's appeal to the Supreme Court was successful. The Supreme Court found that where a person determines that the employee should be dismissed for a reason, but hides it behind an invented reason, which the decision maker adopts, the reason for the dismissal is the hidden reason rather than the invented reason. So in this case, the line manager had manipulated the evidence given to the dismissing officer. Before this case, it was common to defend whistleblowing claims by saying that the dismissing officer didn't know about the protected disclosure and therefore their decision to dismiss was not made because of that protected disclosure, because they didn't know about it. Following this case, this cannot be a defence anymore. This isn't something that we can say to defend these types of claims. If there has been a protected disclosure, then the dismissing officer needs to know about it because it could be attributed to them in any event. The dismissing officer will need to show that they have taken the disclosure into account and that they are satisfied that there is not a causative link. It is important to note in this case that the employee actually didn't attend to the hearing because she was off sick at the time, and this is obviously quite unusual. If she had attended, she would have stated her case and the outcome may have been completely different. So what does this mean for employers? So employers should ensure that they have robust whistleblowing procedures in place which give a clear indication of who to report protected disclosures to. It is important to ensure that dismissal decisions are based on accurate information, and therefore it is vital that all evidence is tested. It is very important to test both sides of the story. It also highlights the importance of ensuring that employees are in attendance at these types of hearings, because that is one way that you definitely can test both sides of the story. So I'm going to take a quick look at whistleblowing following COVID-19. So you may start to see an increase in complaints being made in relation to measures being put in place in response to COVID-19. This is a very unprecedented time, and there is so much guidance on the internet available to employees, which is likely to put employers under greater scrutiny. For example, you may see a rise in complaints about allegations of abuse of the furlough scheme, and that employees are exposed to unsafe working conditions, that there's a lack of PPE, there may be concerns about mental health, and also there may be concerns in relation to failing to follow government guidance on social distancing. If you were to receive any of these complaints, our advice would be to act quickly and consult your whistleblowing policy. You should ensure that staff know where the whistleblowing policy is located as well. Something else we would advise is that training could be given to managers to assist them in spotting any potential protected disclosures in the COVID-19 context. Finally, going back to the case of duty, make sure that all evidence is tested and there is transparency in relation to any decisions which are made, especially in relation to dismissals. So I've had one question pop up. So someone is asking, do you have any advice as to how to potentially reduce the risk of employees making complaints on a return to work? So my view on this is communication is key. I think it would be helpful to be fully transparent with your staff about the measures that you are considering putting in place or that have been put in place in the workplace. Getting employees on board with what you're doing is really important, because if they're on board with what you're doing, they're obviously much less likely to complain. If employees do have concerns, you should encourage them to raise them with you, and you can discuss them before it got to a point where they were making any protected disclosures.
Another question's just come in again, Emily, whilst you've been talking, which is, it's a question about how broad the interpretation of in the public interest is when in the context of a whistleblowing claim, and that is really going to be fact specific. Emily mentioned that a lot of the time employees will raise something that they call a whistleblowing, but actually it's a grievance about them not getting on with their line manager, or that there has been racism or sexism in the workplace. That, I would say, wouldn't be in the public interest, because that is a grievance, because it's about them. And whilst it makes potential allegations of breach of the Equality Act, because it's about them, I generally wouldn't say it's in the public interest. The kind of thing that would tip the balance would be if it was maybe a collective group of employees that were making allegations of race in the workplace, breach of the Equality Act. Perhaps that might tip the balance because it's about a wider group of people. Or in the same scenario, allegations of racism, sexism in the workplace, if they're against a particular senior person, say an executive director, member of the board, perhaps that might make it in the public interest, because stakeholders of an organisation are probably like to be very concerned that allegations being made of someone at that level who's got responsibility for an organisation. So really, public interest it turns on its own facts, but it's more cut and dry when you've got allegations of kind of fraud, financial mismanagement. That is more likely to be in the public interest, particularly in the sector that a lot of our clients are in, the housing sector. A lot of you are dealing with public funds, whether that be grant or housing benefit, and it's very likely any allegations of fraud or financial mismanagement would be in the public interest in that context. Okay, I think now Emily's section is over. I'm going to move on to looking now at returning to work after lockdown. I just need to access the slides. Perhaps Emily, you could move it along. Oh no, I've got it now. Sorry, the pitfalls of having two hosts. Right, I should be able to move it now. Right, yes. So I'm going to move on to talk about return after lockdown and what needs to be considered. I obviously mentioned at the outset of the session, some of your offices may already be starting to open up for skeleton staff, but really the aim of me talking about this today is to kind of give you an overview of what employers need to be doing, but also talk through some of the inevitable scenarios of employees not wanting to return to work or the office for various reasons. So from mid-May, the government guidance changed, which was that employees who can't work from home should be actively encouraged to go to work. That didn't change the position on working from home, which remained the same, that where you can work from home, you should continue to do so. but it changed the position for those who can't work from home, from only going to work where it was necessary to being actively encouraged. And as employers, you will have a duty to maintain a safe place of work for your staff. That duty has always been there, but obviously it's heightened in light of the COVID-19 considerations, and there was government guidance that was issued that employers need to be doing various things in order to ensure that workplaces are COVID safe. So looking at continued remote working, adjusting working hours, looking at social distancing in the workplace, and putting in place screens, one-way systems, PPE where social distancing can't be observed, more frequent cleaning, but also doing a risk assessment of the workplace in consultation with staff, in order to ensure that you are going to be providing a safe place of work for employees to return to. And I'm sure all of you saw or heard in the last couple of hours, it's been announced by Boris Johnson that from the 4th of July, there's going to be a reduction of the social distancing requirements. So it says that 2 meters should try to be observed. Where that can't be observed, there's going to be a reduction to not just 1 meter, it's apparently 1 meter plus. So we haven't quite nailed our colours to the mast on that, but so it'd be 1 meter plus, and obviously that was breaking in the last couple of hours. So it remains to be seen whether the employer guidance will now take account of that. And if it does, then the requirement to social distance in the office is reduced to 1 meter plus. That may allow employers to open up offices more, because they will be able to fit more kind of desk space in, spaced out in that way, rather than 2 meters as had been previously. I'm sure everyone has seen the guidance from the government. There is specific guidance for different types of workplaces. The most relevant one likely to be offices, because that's inside, but also for our clients that have employees that are maintenance employees going out into people's homes, there is guidance that employers should be following to ensure a safe place of work for employees. There's a clear message from the government that employees shouldn't be forced to work in an unsafe workplace. And that's where, as Emily touched upon, the importance of clear communication and consultation comes in. Employees are much more likely to be on board with returning to work if they feel that their views have been taken into account and listened to in coming up with an action plan of how the workplace is safe for them. Employees are being directed by the government to contact the HSC or their local authority where they have concerns about health and safety at work, and that feeds back to our point that there could well be a spike in whistleblowing complaints as a result of this. And as Emily mentioned, the employer duties have always been there, but they kind of were in the background. Certainly, for me as an employee going into the office, I never really thought about how my employer was making my workplace safe. But now there's reams and reams of guidance on the internet. It just takes a quick Google for employees to have a look at what employers could be doing. So I think employers are definitely going to be under more scrutiny in relation to making workplaces safe. There is an underlying theme in the government guidance about making socially responsible decisions in respect of employees that don't want to come back to work. And I will come on to in a moment kind of different categories of employees and how and the various treatments that you may want to put in place in respect of them. Just because employers are encouraged to make socially responsible decisions doesn't mean that all employees, regardless of circumstances, should remain on full pay, at home. But employees need to think carefully about going through any form of dismissal process for someone that doesn't want to come back to work because of COVID-19. And as I said, I will come on to specific categories in a moment. This equally applies to employees on furlough because of health, age, pregnancy or childcare responsibilities. Whilst from 1st of August, employers are going to have to financially contribute, the scheme isn't actually ending until October. So employers will need to think carefully about bringing people back to work earlier. If there is an added element of health, age, pregnancy, childcare, and need of good reason to bring people back. So looking at furlough and the end of furlough in particular, for many clients, they will have furloughed employees during the lockdown and the COVID-19 crisis for a variety of reasons, whether that's a downturn in work, whether it's someone that has been shielding, is clinically vulnerable, or who has childcare responsibilities. You may now be looking at bringing people back to work, and we've had lots of questions from clients on how people do that and the practicalities of that. So depending on the drafting of whatever you've put in place with the employees when you agreed furlough, the furlough perhaps will agree on a defined end date, but even if it doesn't, you should ordinarily have built in notice for you to bring the furlough period to an end on X amount of notice, say 1 to 2 days. So you would ordinarily look at ending it like that. The general position on the ending of furlough would be that the temporary variations to the contract as set out in that furlough agreement will end, and they will revert to their normal terms and conditions. I have got clients that have, in addition to furloughing, applied for example, 10% temporary pay reduction across the board to save costs. And when people are coming back from furlough on full pay, there is going to be a disparity in the treatment between those employees and the ones that have been working throughout. So clients may look at wanting to make a further contractual variation to the employees returning from furlough, and you can do that subject to the normal rules on making changes to terms and conditions of employment. General principle being consent is really going to be the best option here, because you wouldn't want to unilaterally vary someone's pay, because that is likely to result in a claim against you for constructive unfair dismissal, and you wouldn't want to dismiss and re-engage someone to have to implement that change, because that is going to take time. You need to follow a fair process, serve notice, etc. For long-serving employees, that can be 12 weeks. From the 1st of July, employers will no longer be in that all or nothing scenario that they've been in before, which is someone's either on furlough or they're not, and during furlough that person can't do any work for the employer that would generate any sort of income. Flexible furlough is going to be in position from the 1st of July, and it means that employers can agree any sort of working pattern with an employee and still claim from HMRC, from the job retention scheme, for the hours that the employee is not working. We actually did a webinar on this last week, which is accessible through our website should you want further information on that topic. So what happens when you want to bring people back to work? So, as I mentioned before, the overarching principle of people working from home where they can remains. And actually, employers are at the moment really only looking at bringing back those to the office that are needed there. And inevitably, you are going to get pushback from some employees who don't want to come back to the office. whether that be because they are on furlough at the moment and they don't want to come back to work, or whether that be because they're working from home and they don't want to return to be office based. So for employees that don't want to come back to work, as mentioned on the slide, each case has to be considered on its own facts, because you will need to think about the individual circumstances of each employee. So looking first at that first category of shielding. So if somebody is shielding, they are someone who's defined as clinically extremely vulnerable, as opposed to someone who's clinically vulnerable without the extremely part, which I'll come on to in a second. So for someone that's clinically extremely vulnerable and shielding, they may be furloughed, and to force them to come back could amount to a breach of an employer's duty of care, or the implied term of trust and confidence, and it could result in claims. A lot of you may have seen that it was announced yesterday that the shielding advice is ending at the end of July. However, the guidance is clear from the government still, that those who have health conditions where they're shielding, or those who live with someone that's shielding, should be supported to follow the government guidance where they can. So for someone that is shielding until the end of July, from the 1st of August, the government guidance is that someone can return to work provided their workplace is COVID secure, and they're no longer entitled to SSP after that date. So you may have been aware that someone that was shielding, if they weren't furloughed, was entitled to statutory sick pay from, I think it was from mid-April. They weren't furloughed, and even if they weren't sick, but that is going to cease as of the 1st of August. So for this category of people, as I said, from the 1st of August, they can strictly come back to work, provided the workplace is COVID secure. So for someone who you're looking to bring back to work, who is shielding after this date, then our advice would be carry out your individual risk assessment. If you can't mitigate the risk to them of them carrying out their substantive role, can you look at if there's another safe role they can do in the workplace? If there isn't, is there anything they can do from home? The fallback position, kind of last resort for people in this category, would be to get them to use annual leave or unpaid leave. But that would always be a last resort. And actually, if you've got someone that's furloughed who has a health condition that meant they were shielding until the end of July, our general advice is that that person should be kept on furlough to the extent you can until the end of the furlough scheme. Whilst obviously from the 1st of August that will come at a financial cost to employers. To bring someone back on the basis of cost alone isn't going to be, you will need something else to tip the balance, because if you're bringing someone back because you can't afford to pay the small proportion of pay for furlough, then surely the same pay consideration comes into account when they come back to work and have to pay them full pay. And actually, if it's about pay, you're probably more looking at a redundancy scenario, because the business can't sustain paying salaries. For someone who is clinically vulnerable, so I use that as an alternative to someone who's clinically extremely vulnerable. The advice would be the same, which is if they're on furlough at the moment, strictly you can look at bringing them back to work. However, do your individual risk assessment, look at whether there is anything they can do in the workplace that is deemed to be safe. If their substantive role isn't, is there anything they can do from home? If not, the fallback is annual leave, unpaid leave. However, again, we would advise that the best scenario would be for these people to be kept on furlough to the extent they can be, if they are unable or unwilling to come to work because of their health. The only category of people that I also wanted to pick up separately was pregnant employees. whilst they fall within the category of clinically vulnerable, they do need to be treated slightly differently. And the reason for that is there is the ability on the requirement for employers to consider suspending them on full pay if there is no safe work that they can do in the workplace. So they are a potential category that should be, if they can't be furloughed, you should consider suspending them on full pay if there is no safe work that they can do. I guess one last point on that clinically vulnerable and clinically extremely vulnerable groups is, if you're in your last resort position of they can't be furloughed and there's nothing else they can do, and you're looking at annual leave, unpaid leave, there's a potential argument they could run, which would be that they're ready, willing and able to work. It's just the employer that is unable to provide them with work, so they should be on full pay. So that's just something to keep in the back of your mind, that as a potential argument they could run if you find yourself in that last resort position, if you cannot keep them on furlough or you can't find them anything safe that they can do. Looking at the second bullet on the slide, well, the second bullet, second sub point on the slide about childcare. So you may well have put people on furlough because of childcare responsibilities, and that being a barrier to them to be able to work. You can keep people on furlough until, well, let's say September, assuming schools start in September, if you wanted to do so. If you have a good reason to bring these people back, then they still say they can't come back to work because they have to look after their children, then you were potentially looking at either unpaid parental leave, leave for someone to deal with an unexpected event or emergency, although I question whether it's now an unexpected event that schools are closed, because people have known about that since March. Or you'll look at annual leave, but given that the summer holidays will be starting in, say, a month's time, it's unlikely someone's going to have enough annual leave to use for the whole period, so they may fall into needing to use unpaid leave. So for that reason, you may want to consider keeping them on furlough. And I come on to in a minute potential discrimination claims if employers decide to take a blanket policy of bringing everyone back from furlough when it starts to cost them money from the 1st of August. You may also find that employees that have been working from home for the lockdown period actually really like it. They want to continue working from home. They like the fact that they don't have to commute or spend money commuting. And so we would anticipate you seeing an influx in people requesting to work flexibly. Obviously, you will have one of 8 business reasons that you can refuse flexible working requests, and it will come down to whether that person's job can be carried out at home. But I think you'll have to bear in mind it's going to be much harder for employers to justify refusing working from home, given that someone has potentially successfully been doing it for the last 3 months. So care should be taken when refusing flexible working requests as well. And actually, I think a lot of employers are going to use this as an opportunity to reduce their office space, because they've realised actually their workforces can operate quite efficiently from home, and they perhaps don't need all the space that they've got in the office. So it could come at a benefit to organisations as well if a percentage of their workforce wants to work from home for part or all of the week, because it means you'll be able to save on office space. Looking at annual leave. Oh, sorry, I just missed on that slide. I would say for an employee that refuses to return to work, strictly a potential disciplinary process if someone doesn't come back to work. But I think because of the emphasis on making socially responsible decisions and the government guidance on not forcing employees to come back to work, I would advise employers to proceed with caution with any disciplinary route to dismiss someone because they don't want to come back to work. and really you'll need to understand the the reasons why that person doesn't want to come back to work, and work with them. And this again comes back to what Emily and I both mentioned, which is getting buy-in from employees on making the workplace safe and ensuring people are comfortable and happy to come back to work, and their safety isn't going to be at risk, or any risks will be mitigated to the extent that they can. Moving on to annual leave, I'm mindful of the time and I wanted to leave a little bit of time for questions, so I will just briefly go through these last couple of slides. So annual leave is likely to have been an issue this year for all our clients, and actually the default position we're seeing now is most clients are requiring employees to book annual leave, at least half their entitlement in the year. Or if they don't, say serving notice for them to serve it, to take it on specific dates. Legislation was introduced during the lockdown, which enabled employees to carry over any working time directive holiday, so that's the first 20 days, for up to 2 years, where it was not reasonably practical for them to take it in that leave year as a result of the effect of coronavirus. And so that is quite a wide definition. However, if you think about it, most holiday years are either January to December or they're March to April. So actually there is time for people to take holiday in this year. And really, I think actually that legislation was only really introduced for key workers who can't physically take their holiday because they are absolutely stretched and they need all their staff there all the time. So really it's unlikely that any of our clients are going to need to rely upon this carryover, unless, for example, if your holiday year is unusual in that it's done on the anniversary of someone's employment, for example, and they started employment in May. If it runs from May onwards, actually certainly in March onwards, there'll be a significant proportion of the year that they won't be able to take it. But even then, there's still time kind of at the end for them to take it. I guess really, what I'm saying is it's unlikely you're going to need to utilise that, but it is there, obviously, and drafted quite widely should you need to do so. You may have seen in the last couple of weeks about the quarantine rules as well. So anyone coming into the UK, save for certain exceptions, will have to self-isolate for 2 weeks. For those who can work from home, then actually it makes little difference to their ability to do their job because they're just doing what they're doing now. But for someone who can't work from home, that is going to have an impact, because either you allow them to take the annual leave and then you agree they have another 2 weeks annual leave afterwards, or employers may agree a period of unpaid leave. For someone to take 3 weeks annual leave in a row is obviously it's quite a big chunk, and you'll need to consider whether you can cover that absence. But actually it can be quite useful if you're trying to get employees to take their holiday before the end of the holiday year, that person's entitlement is probably then entirely used up by virtue of them needing to remain at home for 2 weeks after they come back from holiday. But I would say watch that space with that one, because even in the last 24 hours, 48 hours, I've seen new guidance about these kind of corridors with some European countries. So that is changing from day to day, week to week, like the rest of the guidance I'm sure you will have noticed. So lastly, just looking at what happens kind of in terms of employment issues if things go wrong. Potential unlawful deduction of wages claims if you have incorrectly calculated furlough pay, for example, and haven't paid in accordance with your furlough agreement. You could get a potential unlawful deduction of wage claim. We already obviously mentioned that we think there's likely to be an increase in whistleblowing disclosures relating to health and safety matters. There is potential increase in unfair dismissal cases if you've, for example, made redundancies, or you've gone through disciplinary processes over Skype, for example. Employees might look at challenging that. not least because going out into this job market perhaps is going to be challenging, and if they can submit an employment tribunal claim for free against the previous employer and get some money out of that, they may well look at that as a means of, getting money until they can get another job. Discrimination, mentioned that if employers apply blanket policies to bring everyone back from furlough, for example, that you could have discrimination claims from those with protected characteristics. Indirect discrimination claims would be the most likely, and you just need to show that you've got a legitimate aim in applying whatever practice you've applied, and that whatever you're doing is a proportionate means of achieving it. Do remember, it can't be cost alone as a justification. You need something else as well, so it's defined as costs plus. So they are defendable on indirect discrimination claims, but you just need to have a good reason. That has to be costs and something else. Lastly, increased absence for other reasons other than COVID-19. The lockdown is thought to have had a big impact on people's mental health and welfare, and so you may well see after a busy period for your organisations, if you've had skeleton staff covering, that you see an increase in absence after the lockdown is relaxed. So it's just something to be aware of. So that was really where I was going to end. So I'll give a minute or two in case of any questions. Nothing's come up yet. But as I mentioned at the beginning, any specific questions, or if you just feel that you want to pick up afterwards, Emily or I would be happy to help. And you will have the slides as well. So if anything occurs to you after you get the slides, then please do get in touch separately. There aren't any questions, so I will let everyone go, because I don't want you have to hang on any longer than you need to. It's 1 minute to 3, and you may well be going off to do other things. So I think we'll end it there. Thank you very much for your time today, and as mentioned, any questions, do get in touch.